Major breaking news. Federal Appellate Court out of the Fifth Circuit Court of Appeals, the United States Court of Appeals, has concluded in a 2-1 decision that I will put down below that the so-called Joe Biden pistol brace rule that says that braces with pistols somehow get converted into short barrel rifles and thus have to be registered under the National Firearms Act is unconstitutional and illegal, both under the Administrative Procedural Act and arguably under the Second Amendment as well. Stay tuned. This is very big breaking news. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out, available on audiobook and in paperback, and of course, at bookstores near you. All right, folks, here's big news. As you know, Joe Biden, as part of his effort to have gun control, but not have to go to Congress and pass a law, he is trying to do everything he can with a pen and a phone and using his power over the ATF to make stuff up, to advance gun control with a pen and a phone using just the executive branch. I'm happy to report today that the United States Court of Appeals for the Fifth Circuit out of New Orleans, Louisiana, has concluded that the so-called pistol brace rule, the 6-part factor that says that if you have a pistol with a brace attached or a stabilizing brace attached or whatnot, that somehow gets converted into a short barrel rifle that's subject to the registration requirements under the National Firearms Act. This has been declared as likely unconstitutional both under the Administrative Procedural Act, or the APA, and possibly even under the Second Amendment's right to improve the guns that you own. But specifically, this court, in a 2-1 decision with Judge Jerry Smith and Don Willett in the majority and Judge Higginson in a dissent, concluded that indeed that Joe Biden's ATF had exceeded its authority in promulgating these regulations without going back to Congress. Specifically, they tell the story right up front. I'm proud to say, on behalf of this court, they told the story right up front that back in the year of our Lord 2012, an FFL submitted a stabilizing brace for a review by the ATF and asked whether the stabilizing brace, when attached to a pistol, transformed the pistol into a rifle and thus a short barrel rifle. That stabilizing brace, when the ATF reviewed it, they concluded that, and this is what the Fifth Circuit said today, quote, although the brace also could be used to shoulder the weapon, the ATF initially indicated that the brace did not transform the pistol into a rifle. Now, a decade later, the use of stabilizing braces and brace pistols has dramatically increased. And of course, it goes on and says that, well, there's no basis for the ATF to change their position because what they've effectively done is enact legislation without going to Congress, and that is unconstitutional in our separation of powers and 3 branches of government system of regulation and government. The good news is that the Fifth Circuit went so far to almost poke fun of, in I think polite professional way, the ATF's notion of this point system, which gave rise to the 6-factor balancing test, and even alluded to YouTube. I wonder if they're alluding to a handsome YouTuber here. I digress. Probably not. Nevertheless, here's what the Fifth Circuit said. Very powerful language. Not me, the Court of Appeals of the United States. Quote, the ATF's final rule on pistol braces scrapped the points-based approach and the proposed rule and instead instituted a 6-factor balancing test considering everything from the weight of the firearm with the stabilizing brace attached to the prevalence of YouTubers demonstrating the likely use of the weapon. Now, I don't demonstrate the likely use of a weapon, but I'm proud to say that, hey, I guess I'm a YouTuber. So we got to mention here on this major 60-page decision by the Court of Appeals. The Court of Appeals then goes on and talks in great detail about how this violates the law. Now, I want to flag something up front here before I get into a couple more of the gritty details. What this court has decided is they're reversing the denial of the injunction and they're enjoining, they're basically enjoining the ATF, but they're sending this back to the District Court of Appeal, to the United States District Court down there in Texas. That's the trial court. Specifically to determine, quote, the scope of the relief. The scope of the relief. Now, this is important to understand. The scope of the relief in this case is going to be set by the trial court. So anyone that has an interest in making sure you're protected and fall within the scope of this relief, i.e. that you are protected under this injunction, you may want to talk with your lawyers or your advisor and see if there's anything you can do, because this is all going back to the United States District Court for an analysis of the scope of the relief. So the Fifth Circuit did the heavy lifting here. They said that this law is unconstitutional and illegal and needs to be enjoined. The scope of it, i.e. who's protected and all those conditions, that is going to be decided by the trial judge. So just keep that in mind. I should remind you that the name of this case, if you're not already familiar with it, is William Mock, Christopher Lewis, and the Firearms Policy Coalition, as well as Maxim Defense Industries, LLC. So congratulations to the Firearms Policy Coalition, a big win for them. And all of this, of course, is against the ATF and Merrick Garland. Just a few more quick points in the 60-page opinion I'll put a link to down below. They actually put in some very powerful testimony by the Attorney General of the United States during the enactment of the 1930s, discussing the National Firearms Act. Basically, the ATF, this is very interesting, the Attorney General of the United States actually said, quote, unbelievable, quote, "I do not expect criminals to comply with this law." Period, close quote. The Fifth Circuit slapped the ATF with this language and says, hey, the Attorney General in the 1930s that promulgated and encouraged the passage of the NFA literally says that I don't expect criminals to apply with this law. That's a direct quote from congressional testimony in the 1930s. This Attorney General also goes on to say, this is, of course, Homer Cummings. He says, I do not expect the underworld to be going around giving their fingerprints and getting permits to carry these weapons, but I want to be in a position to convict them because they have not complied. Again, focusing on the scope of gun rights in America, by virtue of how people misuse guns as opposed to how people use guns lawfully, which the current Supreme Court focuses on how we use guns lawfully, not the misuse of firearms like this, Attorney General. I think this guy was the Attorney General for Franklin Delano Roosevelt, not one of our better presidents, but we'll talk about him another time. There was also a nod in this decision to the United States versus Thompson Center firearms case. That was Stephen Halbrook. We've had him on the show before. He is the one that gave rise to what's known as the rule of lenity. The rule of lenity is very important for you to understand. The rule of lenity says that in interpreting a statute or a regulation, if there's any ambiguity, the presumption is against the government in favor of the individual. In other words, if there is any possibility of a criminal implication of a regulation or a statute, any ambiguity goes in favor of the law-abiding or the American citizen against the government. That is specifically what the Fifth Circuit said here. They cite to the United States versus Thompson Center Firearms and actually discuss the rule of lenity. Again, very powerful language here and very favorable to us in the Second Amendment community. The court obviously understood the practical implications of the difference between a non-NFA registered or non-NFA regulated pistol and an SBR. Specifically, this court said there are immense incentives not to own an SBR, but instead to have a non-NFA regulated pistol. Obviously, if you have a non-NFA regulated pistol, you're fine. If it's an SBR, you have to go through all the headache of the National Firearms Act. And the court here specifically recognized that fact. The other interesting thing this court mentioned is they made fun of, I don't want to say they made fun of, but they really looked askance at, is probably the better way to frame it. They really looked at these factors and you could see them almost rolling their eyes in this opinion, because this is what they say, that yes, we see this worksheet of 6 factors, but quote, the implementation of these 6 factors left much to be desired in practice. Absolutely right, because if you look at those 6 factors, you may recall, one of them, for example, to be considered is, quote, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. So that speaks not only to a First Amendment problem in terms of the right to free speech and the right to a free press, but what does that even mean? How does any American possibly know what the ATF says? And we've talked about this before in the 6 factors that are to be considered, whether or not a pistol and with a brace is a NFA item. This is so sloppy and open-ended that no American could possibly be put on notice as to whether or not they own an NFA item or not. We've talked about that and why that's terrible in this context before, and I'm glad to see the Fifth Circuit flagged it. The last point I want to make, because this is shocking and actually kind of funny in many respects, and the Fifth Circuit kind of flagged this as kind of amusing, I suspect. They point out how many people actually registered these pistols with these pistol braces with handguns. Well, it turns out they guess there's only approximately 8% 8% of the people that had these registered them. Specifically, this is what the Fifth Circuit says, quote, the ATF reported it received about 250,000 applications to register pistol brace equipped firearms before the deadline for this new regulation. For an estimated registration compliance rate on the high end of approximately 8%. 8%. That means 92% of the pistol brace equipped firearms were not registered with respect to the NFA. It's kind of amusing. But anyway, nevertheless, the Fifth Circuit goes on and just makes the observation. The number of pistol braces removed from weapons or otherwise surrendered to the ATF or destroyed is unknown. Yeah, of course. My final point is a concurring opinion here by Judge Don Willett. He just made the following observation that there are Second Amendment implications here, but he didn't feel the need to get into the details because the rule is getting struck down already on non-constitutional grounds. So what he said specifically in his concurrence, this is Judge Willett, quote, in my view, protected Second Amendment conduct likely includes making common safety improving modifications to otherwise lawfully bearable arms. Remember, ATF here agrees that the weapons are lawfully bearable pistols absent a rearward attachment. So, bottom line is, powerful language from Judge Willett. He says he didn't need to get into greater detail than that because, again, the rule's being struck down on other grounds. Nevertheless, a big win for the Second Amendment, a big blow to the ATF, and a big blow to the Joe Biden gun control agenda. I'll keep you abreast as things develop in terms of the scope of this order that's going to be coming down the pike down there in the district court. But a big happy day today for those of you in the world of pistol braces. And again, if you haven't subscribed to the Four Boxes Diner, please do so. And we'll see you again here soon at the Four Boxes Diner.
Orders up. Table 2A.